Morning, everyone. Britt Simon here. Hope you're all well. Hope you're having a good weekend so far. Let's see if we can shed some light on the current DV situation this morning. I'm going to spend the first few minutes actually talking about the lawsuit or lawsuits. There were responses from the government filed yesterday, and they're worth discussing a little bit, I think. There's going to be a lot of confusion about them, etc. A lot of fear and uncertainty, and so on. And it's also important for us to sort of understand strategies, from this point forward. I've got to say good morning to confusion first of all, of course, and good morning, good morning to the rest of you. But anyway, I do. So if you could just indulge me and perhaps hold your questions for a few minutes on the whole, just give me a few minutes, and I will go through the response from the government. That's what I want to do. Couple of things I want to do first. Actually, I should probably do this first. This is going to be relevant, so I want to show you this. Why am I prepared for this? Oh dear. Don't screen that one. I just want to share this latest report. I just reran the report this morning with yesterday's data. Just to confirm that the number of 2NLs issued for the month of June, since we're now in May, the month of June interviews is probably done. That's probably all the interviews that are going to be scheduled. 928. Now, I was just looking this morning. I think this is actually the two lowest months I was just sort of briefly looking at it, but they're probably the two lowest months on record for the last few years, since 2023. So I've been collecting this data since 2023. Reports rather. I haven't been collecting it. This data all comes from SEAC. And Zarthisius has been extracting the data for some time. When he sees 2NLs happening, he marks the date of the 2NL, and I've used that date to determine which month those interviews should be on. And I wrote a little script with the help of AI that pulls this data out and checks how many interviews there are per month. This is important because it kind of shows what it shows a couple of things actually. It shows how many interviews are happening. If interviews aren't happening, if they're not being scheduled, we can't get visas issued, right? That's obvious. Anybody can see that. And time is being lost. In this report, I'm showing 928 interviews for the world were scheduled for June interviews. That's the lowest number on record. In fact, last month's number was the lowest number on record. Unless we go back to the days of DV 2020 and DV 21, when there were just literally bans in place and so on. There was literally no interviews happening for some months during 2020 because of COVID crisis and everything else. But since we've been back operating as normal, so the last 3 years, I'm comparing this data to the last 3 years. There's not been any months that have had less interviews than this month and last month, right? And the reason for that is partially, well, in the case of Africa, the cases are current, but the embassies are not making capacity available, so no interviews are happening. And in the case of Europe, basically they're not moving the VB number. They've kept it at 20,000, and by doing that, they're choking the number of interviews that can possibly be arranged, right? And so we've only seen 306. Now the capacity in Europe, we saw there is. I'm hoping you can see this. Make that a little bit bigger so you can see it better, perhaps. The capacity in Europe was shown clearly to be 1,300 interviews in the month of April, right? So we know the capacity, but that's when the VB was moved to 20,000 from 11,000, right? And so we got a nice large number of interviews then, but that showed the capacity of interviews in Europe. So the government can't say that the embassies don't have the capacity, right? And then that number dropped to 765 the following month because the VB wasn't moved. And so there was just backlog cases being scheduled at some of the embassies that had capacity but in the previous months, but not enough capacity to get to 20,000. So there were backlog cases being scheduled. That's where the 765 came from. And then 306 is June interviews, same thing. The VB didn't move at all, didn't move from 20,000. And so this is backlog cases, but there's only so long, you can only go back to the same pond so many times and fish out of the same pond, unless new fish are born, or unless the pond gets bigger, you can only get so much fish out of that same pond, right? It's just a little pond, right? Just a little pond in my back garden. It had 10 fish in it, and I've fished all but one of those fish. I'm only going to get one more fish out of there, and there's only one fish in there, so unless I make the pond bigger and put more fish in it, I'm not going to get any more fish, right? That's what I'm saying. You can't keep going back to this same 20,000 number and expect the number of interviews to be increasing month after month, which means they are deliberately wasting capacity in EU region, and the embassies in the Africa region are not using their capacity for DV cases. They've decided that because of the pause, they would rather focus on other cases, right? And so this is clear evidence of the damage being done by the visa bulletin. And it's an interesting point because they raised the visa bulletin in the lawsuit response yesterday, and it's quite bizarre. But I'll come back to that in a minute because I've got some notes. I want to go through some notes of the responses from the government, kind of in order, a little bit in order. The responses from the government in the various sections, because there's some bizarre stuff in there. I have to say, their response was well formed. They've done a good job of making certain principles. In general, they've done a fairly good job. There's a couple of glaring errors. Curtis was already on Twitter last night pointing out blatant mistakes in the government's response. And he was right to do so. That he's accurate on that. And I love how Curtis is worked up and fired up about this, and I'm sure the Impact team are as well. And they will be anxious to argue this case with the government. But the government have put a number of interesting points and well-described points, and some of them have strength. And so we do need to consider those points and see whether they'll be arguable by the lawyers, right? Now, let me say before I say anything else, I am not a lawyer. I've never been a lawyer. I don't work for a lawyer. I'm not a lawyer. I'm just a layman, right? So my interpretation of these lawsuits is purely that I've just been involved in these lawsuits over the last few years since the DV 2020 lawsuits, and I've got used to reading some of these documents, etc., and I understand some of it. But I'm certainly not a lawyer, and I'm not a legal expert, and I defer to anybody who's got more educational training in this area than me. So I'm just giving you my perspective as a layman, right? Please understand that I'm not the definitive source on any of this information. This is just my view, right? And so and feel free to argue with me. I enjoy a well-formed argument. I don't enjoy badly formed arguments or bad arguments, but I do enjoy a good argument. So if you want to argue, fine. By all means, come at me. But okay, so I've made some notes, and I'm just going to read from some of the notes. So one of the first things, I chuckled at this one. They say there's no standing to challenge the 2027 program. This is it was slightly bizarre to me that Curtis put this in his lawsuit because nobody's paying him to put that into the lawsuit. But this is just typical of Curtis. He's pissed off with the government and he wants to argue, and he's an arguer. He will fight, and this is why so many people do like Curtis. He is a bulldog. I've called him a bulldog many times before. That's exactly what he is. But he had this cause of action in his lawsuit, trying to force the government to run DV 2027. And then there was a conversation between him and the government lawyer about a week ago, where the government lawyer gave an indication that he felt that the DV27 was about to start anyway. I mean, in not so many words, he said that. And he referred to a release in the Federal Register. That Federal Register release is the release we knew about that was published in March, where the passport rule actually became effective on April 10th. And so the rule and the form itself has been approved by OMB, etc. The rule is ready to go, right? The form, as far as I'm concerned, as far as I know, is ready to go. I assume the background systems are ready to go, and so DV27 could start at any time. I don't know for a fact the background systems are ready, but I assume they've had all this time. And please, I hope they've done that by now. So, so we're on the verge of seeing DV27 released, but nevertheless, it was part of Curtis's lawsuit. So, so the government's response to that part of the lawsuit was, well, DV27 hasn't started yet, and so therefore you've got no standing to challenge. Nobody in the lawsuit has got standing to challenge the fact that the DV27 hasn't started yet. It's a bizarre argument. It's like my head just twisted itself inside out thinking about how stupid this argument is. And I'm trying to think of an analogy for it, and I'm probably going to kill a couple of dogs in this session, but this, figuratively speaking. But this is like, somebody comes onto your property, shoots your dog, and then says, "Well, you can't complain about it. The dog's dead now. What can I? Nobody can do anything about that. It's obviously cruelty to the animal. It's obviously cruelty to the dog." But the dog's dead, so what are you going to do about it? This is what they're saying. You have no standing to sue because DV27 hasn't been released, but actually you're being sued to release DV27. It's a weird argument. Anyway, it's not the most important point, but it is an interesting point, and it shows their mindset. And it was particularly interesting after the conversation that Curtis had with the government lawyer a week earlier, where it would have been very easy for the government to just say, yeah, no problem, we concede that point, and we've got plans to release DV27 in a month's time, or in 2 months' time, or we will run it, as our guidance from November 5th said, we will run it, don't worry about it. They could have said that, but they instead chose to put this standing argument in there. Saying you've got no standing because we haven't released it, and so you can't complain that we haven't released it. So it's weird, it's argumentative, and it's a bit weird that they even sort of argued that point to me, but it is what it is. And standing, by the way, and I'll come back to this, standing is a very strong point in general in lawsuits. Like, if you don't have standing, you can't sue. So, for example, in the UK lawsuit, one of the reasons that I came to realize that I was probably in a fairly unique position to be able to sue the government was because of my position as a talking head in the DV world, because of that, but also because by coincidence, for some reason, I'd got my daughter to enter the DV 2025 lottery period when UK was back on. She didn't enter DV26, but she did enter DV25. And therefore, I was able to, without asking anybody else for anything, in a sense, I was able to demonstrate that through my daughter, had standing. So actually, my daughter sued the government. That's how the UK lawsuit started. She had entered the entered the lottery, and therefore had standing to say she had been wronged. That's what standing is, right? And so that gave me a way of being able to file the lawsuit. And my motivation for doing that was not because of my daughter. I'm a citizen. I can sponsor my daughter if I want to. But the point being that I knew that I could use her to sue, and it would have an effect for everybody else, which is exactly what happened, right? But that's an explanation of the standing principle. You've got to have standing in a lawsuit, otherwise you can't sue. I can't go and sue my neighbor because his friend pissed him off, because I've got nothing to do with that argument, right? I have to be involved in that argument. I have to be I have to have an involvement in the situation. So it's important to prove standing, and that was no standing is their challenge on DV27. Okay. They also use standing, by the way, on and we're going to talk about standing for the next couple of minutes, because they also use standing for people who aren't current. And this is another sort of fairly strong point. So, and there's, to an extent, there's not much we can do about it except showing bad faith in the way they're handling the VB. So let's say your case number 21,000 in Europe. You don't have, technically speaking, you don't have a cause of complaint at the moment for you not being scheduled, because you're not entitled to be scheduled, right? And they point at the visa bulletin and say as if it's not their fault. They say, well, the visa bulletin has not made you current. Many of your plaintiffs are not current, and therefore lack standing. And standing is a strong point, right? And the visa bulletin, the government can't be ordered to move the visa bulletin to an extent. I'm going to come back to that because that's why I showed you that earlier report. It's very obvious what they're doing, but the point is they have now connected the dots for us. So EU stayed at 20,000 for 3 months on the trot, right? And they've frozen the VB number, and they now in this filing say, hey, you can't sue us if you're not current. So because you don't have standing. And so it's very clear they're like putting their hands up and admitting, in a sense, that they are freezing the VB numbers, right? Now we know that there's no justification for the VB numbers to be frozen. Clearly, the math is very obvious. Like, it's very clear from the report I'm showing earlier. It's very clear that there are not enough people being made current to use the capacity. There are visas available. They should be scheduling more people. They should be moving the visa bulletin. That's absolutely clear. I have an email from Charlie from some years ago, who was the guy in charge of the visa office, and he was Mr. VB, basically. He was the one guy that would decide how the numbers would move. And I got an email from him years ago. I asked him a question and got an email from him that confirms my understanding of how the visa bulletin is to be moved, and it is it is a combination of factors. But basically, the capacity of the embassies is important in a systematic way, like the total capacity of the within the world or within the region, not particularly at one embassy, but everywhere. The capacity of the embassies is important. Also, the number of visas available is important, and they adjust the visa bulletin number in order to take advantage of the capacity and the visas, right? That's how it's supposed to work. It's not worked that way for the last 3 months for Europe, even though clearly our numbers show that it should have worked that way. And so they are deliberately, somehow, for some other reason, they're deliberately holding the visa bulletin down. And now in the response of the lawsuit, they're saying, well, you don't have standing because the visa bulletin hasn't moved, as if something else is making the visa bulletin not move. I mean, it's a very it's a very disingenuous argument, and to pretend that it's not their it's not their fault that the visa bulletin didn't move, and therefore there's nothing you can do about it, right? So it's a disingenuous argument, and hopefully I would expect, although standing is extremely strong in terms of the legal principle, I would expect a judge to say, yeah, but you have stopped the visa bulletin moving. If you'd have allowed the visa bulletin to move as it should have moved, then more people would have standing, wouldn't they? You've deliberately taken away their standing through that point, so we're not going to allow you that point. That's what I would hope the judge would do, right? But that's up to the lawyers to make that argument, and that's why I've been providing this report for the last couple of months, because I'm trying to demonstrate. I could see this one coming. I saw this one coming a long time ago. I could see what they were doing, and started creating this report. And I sent this report to Red Eagle Law, to Curtis, and to Impact, to Jesse and Chuck, to make sure they understood the the thumb on the scale that the government are putting on there to reduce the number of interviews that happen, and ultimately now we see to reduce the number of people who've got standing in the lawsuit. So that's important. They point out that the wrong defendants are in the lawsuit. I can't quite believe this one, to be honest. Is that right? Did we really sue Stephen Miller and Blanche? I mean, oh God. Anyway, so they're saying that Trump, Miller, and Blanche should be dismissed. That's true. We should be suing the Department of State, and which would be Rubio, right? And so anyway, that needs to be fixed. I think it can be cured, and I think Curtis can deal with that. But anyway, that's kind of an annoying one. But yes, I mean, it has some strength. So Congress stripped court jurisdiction over the USCIS pause. Yeah. So this is a jurisdiction bar point. It is a strong point, but I'm not sure I've got the patience to explain this one. But basically, there's a couple of lawsuits that kind of that have given deference to USCIS to make decisions, and also Department of State to make decisions without judicial interference, right? And so that's kind of a common theme here. There's a thing called consular non-reviewability, which I'll come to in a little while. It basically says that judges can't criticize consular officers in their decision. Judge, you weren't there in the interview. You didn't see the person I saw, and so I'm making this decision. Thank you very much. You're not going to review that, right? That's basically the principle. So there is this principle of consular non-reviewability, and there's also a lack of jurisdiction over those decisions and over the way that USCIS operates. So there is that. I mean, it's a strong point, but it's a complex one, and I'm thinking that they can probably sort of deal with it. Okay, then we'll talk about the APA stuff, right? So there's the APA is the Administrative Procedures Act, right? And it basically says that whenever the government does something administratively, they have to do things in certain ways. So they have to, for example, if they make a decision to change a policy, sometimes they have to get public opinion about that. They have to have a notice period, and also they have to keep a record of the way they formed that opinion, right, and the way they decided to make that administrative change. Because the government are administrators; they are not Congress, right? Congress make the laws, and the administration of the day, whoever that is, the Biden administration, the Obama administration, the Trump administration, whoever it might have been on the day, they are the administrators of Congress's will, right? And so the administration, if the administration is suddenly going to change everything that it's doing in one particular area, let's say, they're going to make massive changes, and really with any significant changes, they have to justify that. They have to follow the APA. And they have to go through certain processes to justify it. And in lawsuits, we can ask for example, the administrative record that says, how did you decide to implement this DV lottery pause, right? On December 19th or December 23rd, whichever date you want to look at, USCIS or Department of State. Why did you publish that change in administrative procedure like that, right? What was the reasoning behind it? Well, the reasoning behind it was this stupidity of this MIT, Brown gun attack, and who, the guy who shot a couple of people, and it was a terrible thing, and he later killed himself, thankfully, and but that guy had come through the DV lottery process years earlier in 2017. He'd actually been in the country as a student back in the early 2000s. He came from Portugal, this guy, which is a 99% Catholic country. So he's probably a Catholic, I would imagine. I don't know for sure, but probably a Catholic, right? So not their normal, Islamic terrorism nonsense they want to get excited about. But so this is from a Catholic-controlled or Catholic mainly country, an individual who goes and kills a couple of people, including someone from his own country that he knew years ago, right? So it's obviously to do with a personal beef, personal, I mean, the guy was obviously screwy in the head, but obviously a personal thing, not an act of terrorism by DV lottery people. And his DV lottery entry came in 2017 anyway. I mean, he entered the country as a DV lottery winner, a green card holder in the end, obviously, in 2017, years earlier, years before this action took place in December of 25. So, so what the hell has that got to do with DV lottery? And why does that mean you have to pause all of DV lottery? And the administrative record for that, as it was presented, is laughable. There's no administrative record. There's nothing. There's just a tweet from Christy Nunn. And so, so the APA requirements of having a deliberative process and maybe having, if you're going to make an administrative change, maybe having some sort of communication with the public and inviting public comment and going through a notice period and everything else. None of that happened, right? And this is a significant change in administrative process. They want to pretend, the government want to pretend, and in the APA merits, they're sort of describing this, they want to pretend that this is just within their normal course of business. But this is not normal. This is like, they've completely thrown a hand grenade into immigration for 75 countries and for DV lottery and for other people as well. Courts, they're losing cases left, right, and center. They've lost about 10 cases already on this exact same point. But for individual plaintiffs, generally speaking, those 10 cases are mainly individual cases with a couple of group cases in there. But there's, and they're making changes to their policies. They made a change this week about medical professionals, medical physicians being exempted from the 75 country pause. And so they're making little changes in response to the lawsuits, but they're not taking down the whole policy. And the whole policy, the 75 country policy, is based loosely on public charge grounds, but it was based on nonsense data, and it was really a weak case. The DV lottery has no such sort of strength in its justification. So so those things are just like they just decided to try and throw a spanner in the works, as we would say in the UK, or a wrench in the works. They just decided to screw the whole thing up and reduce legal immigration as much as possible, which they've certainly achieved that goal. I mean, they've done incredible damage this year to legal immigration. Legal immigration numbers have dipped tremendously, which will have an impact on DV lottery in years to come, by the way. But it's dipped tremendously because of their action this year. So so yeah, it's really, really bizarre. But the APA, in my opinion, the APA claims the fact that they haven't followed the APA is probably, the stronger part of the way to attack these particular pauses, both of them, the DV lottery pause and the 75 country pause. I'm not talking about the travel ban; that's a different thing. I'm really just talking about the pauses, right? And so they make arguments, but their arguments are not as strong in the APA area. I can tell you the government would love to kill this lawsuit through the standing and through, they don't want to get to the APA arguments because they know they lose on the APA arguments, right? So they would love to find some other way, which is why they've put these strange sort of standing arguments in there. They would love to find some other way to say to the judge, you should dismiss this lawsuit because of standing. So that they don't have to get into the APA arguments because they know they lose on APA. Clearly it's arbitrary and capricious. Clearly they're doing, there's this final, I made a note here about the final agency action thing. Pauses are not final agency action reviewable under the APA. Well, they bloody well are for DV lottery. They are final agency action. And this is also goes to the Karamova case as well. if you put someone onto 221G in a DV lottery case, and 30th September comes along, that case is done. There's no continuation of that case after the 30th of September. So, so their final agency action thing, what they're basically saying is that this administrative change is not a final agency action, meaning it's not our permanent policy, and therefore we didn't need to follow the ABA, right? And separately, they're also arguing, similar to Karamova, that 221G is not a permanent thing. So you can't really complain about it, but it is an adjudication. They're making these sort of confused arguments, and they could be strong arguments, but at the same time, I'm pretty sure our lawyers can, attack those, because this clearly is. It's a change of. They're trying to change immigration law. So, with regard to the final agency action thing, they're trying to change immigration law through administrative change. And if you're going to do that, that is pretty important, powerful thing you're trying to do. And really, you should be going back to Congress, because you're not in charge of making new immigration law. So, so anyway, that's another thing. Bulls is committed to agency discretion. Yeah, I think I've covered that. And the arbitrary and capricious. They are clearly arbitrary and capricious. The delay claims, Karamova, a lot of people got excited about Karamova this week, because in Curtis's live session, he took 2 bites at the apple, and he talked about Karamova, saying, firstly, he wasn't very worried about it. And after a few minutes of his live session, I think this came at about minute 40. If you want to watch Curtis's live session, which he published on Wednesday, it was at 3 p.m. on Wednesday. And about 40 minutes in, he's asked a question about Karamova, and he says he's not very worried about it. And about 4 or 5 minutes later, he came back to that. And one of the reasons that he said he wasn't worried about it was that he hadn't found anything where Judge Leon, had really taken much notice of Karamova, and so we didn't have reason to try and think that that Leon was going to be sort of very moved by Karamova, troubled by Karamova. About 4 or 5 minutes later, he had actually done a little bit of research, I think, or somebody had for him, and sure enough, they found a case where Judge Leon had taken note of Karamova. Now, Karamova, that whole thing is, when you put onto 221G, so let me just read you this little excerpt that I got here. It says, Karamova held that once a visa is refused under 221G, that refusal is final, and there's no legal duty to further process it. That's what they achieved in this lawsuit called Karamova, right? Multiple district courts have followed this. The government's reliance on it is well placed, although one recent district court, Ascari, I think it is, pushed back on the blindingness, a minor crack worth watching. So that little quote there I got from AI, and I thought it was quite nicely summarized, actually, about what Karamova is and what you can do about it. Now, I could go to various places where I can show that the government say all the time 221G is not a final notice. Like if you've got 221G and you go to your SEAC data page, it says on there, there's a long wordy description. It says on there that it can be reviewed and it can be changed later. So it's not a final refusal. If you Google 221G and USCIS, you'll find a web page where it describes what administrative processing is and how it's not a final adjudication and so on, and that it can be, your case can be reconsidered. There's tons of stuff where we are being told by the government that 221G is not a final refusal, but Karamova somehow achieved the argument that it is a final refusal. And so it doesn't make sense to me that that you can't interfere with that because of consular non-reviewability. I'm sure the lawyers, will need to put some effort into attacking that particular thing, and we may see these cases. I hope to see Karamova clarified or frankly overturned, because 221G clearly isn't a permanent final refusal. It's not a final refusal. It's deliberately not a final refusal. And the other point about that is it's one thing it's saying a final refusal from that consular officer. But if that consular officer is being told centrally, your only choice is to put all the cases on 221G, then that isn't his decision or his or her decision. That's not a consular officer's decision. That's an instruction from from the Department of State, which we've got the cables that says you have to put all these cases on 221G. It's a holding pattern, centrally instructed, and therefore it's frankly not appropriate to sort of hold it in the same way that it was held in the Karamova case. So in other words, you may have achieved a win, Mr. Government, in one particular case where a case really had been adjudicated and really had to be put on 221G for some reason. And yes, you're entitled to do whatever security review you need to do, whatever review you need to do, but you're now using that same status as a blanket way of holding or putting on pause all of the cases. That's not appropriate. You can't say that's now shielded from the court's review. And I think actually the government have done themselves a disservice by doing this, because in my opinion, I'm hopeful, let's say, that the lawyers can actually pull that Karamova bullshit apart and say, no, that's not the same thing at all. And it would actually weaken the 221G position and begin to sort of probe this, this sort of hands-off approach that they got on that. So anyway, they will be strong on. They will be strongly arguing the Karamova claims, and the consular non-reviewability claims, but those claims should be pierceable by the fact that it was a centrally commanded instruction to put cases on 221G, and the timeline of DV, meaning that these cases will expire. You can't just put them on a holding pattern forever and say, oh, we did our job, right? No, you can't do that. And again, I think that the judge, I'm hoping, will see that that's clearly unfair. The delay, so the delay stuff. I mean, this consular non-reviewability and the Karamova thing, they're sort of delay claims. There's another delay claim, which is they make another claim that says even if a delay exists, it's not unreasonable under the track factors. Well, there's a couple of track factors which are, I think it's number 3 and number 5. It's about human welfare. It's like, are you doing harm to humans? You clearly are, and that's particularly relevant in a DV case as opposed to other cases. In the Gomez lawsuit in 2020, that started off as many types of visas, not just DV. It was actually funded. It was an AILA case originally. The Gomez case was an AILA case under Jesse Bless. But he also got assistance from, I think it was Maya Brown and a couple of other law firms that provided assistance. They were more interested in the H-1B cases, and they wanted to get involved for other things. But they formed this sort of legal team, funded partly by the by AILA and partly by the private lawyers. And most of the interest was in the other cases like H-1B and so on, because there's much more money in those cases, right? There's much more money at stake. There's more lawyers involved and that sort of thing. But the DV case is the only one that survived. It's the only type of visa that survived and actually won in the end because of the sunset date that is there for DV cases. We've got a deadline, 30th of September. You can't go beyond that deadline. And so, once that was clear to Judge Mehta in that case, he did a couple of things. He first of all told the government, yeah, you've got to start issuing cases. You've got to start adjudicating cases. And he said that on September 4th. And between September 4th and 30th, They scheduled 7,000 interviews, and they interviewed some number of people, and they issued about 7,000 visas. And so they did a great job. The government did a great job, and those people were able to then enter the country, some months later, after the COVID crisis had died down and the new government administration was in. Judge Mehta also preserved visas for after the 30th of September with a plan that we could argue that one later and maybe come back to that. And in the end, that was appealed, and that part of it was overturned by the appeal court and said, no, you can't issue those visas after the end of the year. So the deadline is firm, and and so we have that firm deadline to tackle with, and harm is being done therefore, right? And so under the track factors, back to the track factors and the delay, under the track factors, it is very clear that there is human harm being done and will be done on 30th of September, apart from the fact that I can also point to the report that shows they're not interviewing people, right? So the terms of the pause said, we'll do all the other things. We'll schedule people for interviews, that people can attend their interviews. We'll do everything else except we won't issue the visas. Well, that sounded innocuous, but that's not what's happening. What's actually happening is that by suppressing the capacity in Africa and by suppressing the visa bulletin movement, they're actually causing very few interviews to happen, and therefore losing time. They're throwing visas away, and they know they are. They know they're doing it, right? And so they're not even playing fair by their own policy. It's a very disingenuous position they've taken. So anyway, so that's another one. Constitutional claims. Yeah, this is a bit highbrow. I'm not even sure I want to go into it, but they've made a couple of constitutional claims, and then this is the one that's got people talking. In terms of the relief, what they've said is any relief in the lawsuit, the government have said any relief given in the lawsuit, if they were to lose, must only be given to named plaintiffs only, no universal injunction, right? Now that's interesting. It's really interesting that they've decided to put that in their response. And people are understandably concerned about that. This was kind of a risk that people had to contend with when they were considering whether to enter the lawsuit or not. There is a possibility that Judge Leon gives relief in this lawsuit, but only for named plaintiffs. And we've seen that play out in a number of lawsuits now. About 10 lawsuits have achieved injunctions and various wins. But every single time, as far as I'm aware, those injunctions and wins have only been for named plaintiffs, people that have actually sued, right? And so it is possible that that's how we end up in these lawsuits. And Curtis won't argue that. Impact won't argue that. They've got no reason to argue that. In fact, I would argue they would be unwise to argue that. So the government have said we don't want this to apply to anybody except plaintiffs, and Curtis is just going to say yes to that. Of course he is, because he's being paid by his clients. He is not fighting for people that haven't paid him. He's fighting for the people that have paid him, right? And that's his job. That's what he's got to do. Same with Impact. They have to do that. You can't hold that against the lawyers when they only achieve, if they achieve a win that is only crafted for their plaintiffs, because that's, that was everybody knew that the rules of that game, right? The lawyers said, we've got a lawsuit, we suggest you be on it. You then all had a chance to either be on the lawsuit or not be on the lawsuit. And if the lawsuit achieves a win but only for plaintiffs, well, that was your decision. Now, there's a possibility of a follow-on lawsuit. I think Red Eagle are going to do another lawsuit, so that you might choose to be involved in that lawsuit, for example. And I should imagine the interest list for that lawsuit is probably swelling, and I should imagine Impact may do the same thing. So, Impact or Red Eagle may launch another lawsuit that will give you a chance to get on the bus, a second sort of chance of that. But it's not guaranteed, and time will be short. And so, you need to understand what the pros and cons are. And I can't advise you one way or the other. I'm not pushing you to be involved in a lawsuit or pushing you to not be involved in a lawsuit, but just understand it is a possible outcome that the lawsuit will achieve a win, and only for its plaintiffs. However, that doesn't mean that the government couldn't then turn around and say, you know what, we're going to take down the DV lottery pause, or we're going to, we're going to take away both pauses, or whatever. They might do that, right? And why would they do that when they've just lost a lawsuit? Well, because it's a bit complicated. It's quite cumbersome for them to operate on a basis of saying some people are going to be treated differently at all these embassies around the world, depending on whether you were a named plaintiff on the lawsuit or not. It would take some work to do that. Once they issue the visa to someone, that part of it isn't complicated. If you hold a visa in your hand and it's a valid visa, you can arrive at in America, and the Border Patrol don't know anything about any of these lawsuits. So if you've got a visa in your hand, you're getting in, and once you're in, you're fine, right? So that part of it isn't complicated. What is complicated and cumbersome is if you've got 2,000 people, let's say roughly about 2,000 people on these two main lawsuits from Impact and from Red Eagle. Those people are at all sorts of embassies around the world. Are they really going to forward a list of people that embassy can handle, can't handle, or whatever? I don't know. It just seems a bit complicated to me. And it seems like there's a possibility, not a certainty, but a possibility that the government might say, this is too complicated, and we'll just, get on with it. There's also a possibility that Judge Leon somehow says, even though both parties have agreed that the plaintiffs should be the only ones covered, the judge himself may see that as unfair and may do something about that. But I think that's quite a small chance. I don't think, generally speaking, judges don't want to try and get involved in that sort of decision. Sometimes they've hinted, and in fact, I think it was in the Gomez case, or one of the cases I remember, Judge Mehta sort of hinted almost in one of the hearings, if you had a class, this would probably be approved, something along those lines. And he basically pushed the lawyers, and the lawyers said, all right, thank you very much, we'll do that. And they did that. So there was one of the cases where the judge kind of involved himself a little bit like that. Whether Judge Leon would do that or not, I don't know. He's a by the rules kind of guy. I'm not sure he's going to sort of step outside the boundaries at all to sort of drop that hint. So he may just do what both sides will ask him for, which is, to make the argument about plaintiffs only. That's a possibility that we've got to consider. And it probably seems a bit stronger now that the government have put that in their reply than before. So yeah, that's interesting. So, in my opinion, having read the motion, the way the lawyers have to attack this, they have to deal with all those standing things for sure. They have to deal with those things, and they have to cure the lawsuit. They have to make sure they get through the standing. They need to get to the APA stuff. I think the APA stuff is very strong. Arbitrary and capricious, the lack of administrative record, the lack of deliberation, the lack of following procedures, etc. in the APA. That's big. And then there is harm being done. The track factors 3 and 5, that there is harm being done, and it's human harm, and and that's going to be important. And then just sort of undermining the logic behind the 75 country pause. Such as it is, there is logic behind the 75 country pause, but it's very weak, very strange logic, very bizarre logic, and there's almost there's no record of logic being applied to the DV lottery pause, and it just doesn't seem to be logical at all. So those are the most important things they still need to go at. I said yesterday, I wrote something yesterday which I thought was going to be prophetic, and it turned out to be. I said yesterday morning, before I saw the reply from the government lawyers, I said it will be probably good, and it was. It's good. It's well worded. It's well constructed. I mean, they're lawyers. They're paid to do their job, and the government doesn't hire complete idiots. They might be defending a weak position, but it doesn't mean they're not going to give it their best go. Of course they will. They're giving it their best go, right? And so I said it would be good, and it would scare a lot of people, and it has. And doomers would doom, and they are. And so, but I'm not personally, these lawsuit things have to play out. You're going to have, you're going to have responses from both sides, etc. Now, Curtis and Impact have to respond to this response, and then ultimately they'll get to argue that in front of the judge. I think it's more likely that there will be an oral hearing now in front of Judge Leon. I think that's almost, I would say, a very high chance of there being an oral hearing, because these matters do need to be considered. But there's nothing insurmountable. There's no sort of complete gotcha in this response. So we're still in a strong position. But this plaintiffs, non-plaintiffs thing might be important to some of you. You need to think about that. Okay. All right. God, that was a long time. I said I'd take a few minutes on that. I spent 50 minutes on it. So I apologize if any of that is uninteresting to you. And you should probably hear all this from the lawyers. As I said before, as I said at the beginning, I'm not a lawyer. This is just my personal take on what I'm seeing here, and I'm just along for the ride, like many of you. And many of you are probably more legally au fait than I am to make your own assessment. So by all means, do that, or ask the lawyers, right? Okay. So let's take a few of these questions. See if I can get through some of these questions fairly quick. Joe says, bizarre question. I think your stream may have mentioned it, but is there a statutory requirement on how long the entry period should be? Is it strictly 30 days, or is there a range? It's one I've not found, actually. I've looked for that, Joe. I don't know. There was a comment made by someone that suggested they were going to have a shortened time period for the entry period. I don't think it can be shortened tremendously, but I have to wait and see. We'll have to wait and see how that is. We're in May now. I was expecting them to announce the lottery period to be, I was expecting them to announce it in April, to be held in May. That could still happen, that it would be held in May, but time is ticking, So, like I say, it's weird that they responded in the lawsuit in the way they did, rather than just saying, yeah, we're planning to open it next week. Don't worry about it. Right? It's like, oh man, why are they arguing? So I don't know. We'll see what the time period will have to be, but I don't have a clear answer for you, Joe. I'm sorry. Let's see. I had my interview on February 26th and received 221G form. As per current situation, should I pursue a lawsuit? If so, could you advise which law firm I should choose? Right. There are still there's at least two law firms dealing with this. I think there may be another one, sure, but Impact and Red Eagle Law are your two choices that I know of, right? Red Eagle have an interest list, so you can Google for yourself. You've got Google, you don't need me to give you the link. You can Google Red Eagle Law, and you can look at their interest lists link, and you can sign up for that interest list. The interest list doesn't mean for sure that they will file another lawsuit, but if they do file a lawsuit, they'll have to move pretty quickly, and so you probably want to get on that interest list in order to to make a decision later. I think Impact may also file another case. I don't know. I hope so. I'm not sure. I'm not sure whether they will or won't. I haven't spoken to any of the team about that. But they may file another case. And I think yesterday's response from the government and this push towards plaintiffs only might encourage a few more people to sort of get onto the lawsuits. And if you do, get onto a lawsuit, think how you want this argued. Do you want Curtis to argue for you, Red Eagle Law? Do you want to work with that team, or would you rather have Impact Team, which is Charles Cook, Jesse Bless, and so on? Which team would you rather have argue for you in court if it comes to that? I have to say, and I don't mean this at all disrespectfully, but I have to say, I'm kind of in favor of the older guy, in that particular race. If I had to have my druthers on some of these claims, claims that are going to be complex to argue in an oral argument situation, Charles Cook would be the guy, or perhaps Jesse Bless would be the guy I would want arguing those cases. Curtis is great with the background, and he's great with onboarding cases, and he's great with these large lawsuits, etc. But if you had them all in a room and you had to have one of them to argue for you to save your life, then I would probably go Chuck Cook, Jesse Bless, Curtis Morrison, probably in that order. It would be kind of like that. Now that's a bit of a that's kind of a tough thing for me to say, because I love them all, and I've got great respect for them all. And as I say, they're all achieving great things. There's also Greg Siskin out there as well, but he's not sort of the guy I've seen arguing. But I've seen all three of those people argue. I've listened to or seen all three of them argue, and that's my personal assessment of how they would argue, how they react to what the judge is listening to, what's how they craft an argument. I'm a pretty good arguer, I have to say, and I know who I could win arguments against, right? And I think I'd be able to argue against Curtis most days of the week, and I'd be in pretty good shape. I'm not so sure about Jesse at all, and I'm damn sure I wouldn't win an argument against Charles Cook. That's that's kind of where I sort of see things. That's kind of where my assessment is, right? Anyway, that's just my personal opinion. You can take it or leave it. It will depend on whether both law firms add on follow-on cases, to be honest with you, and what the costs are and that sort of thing. You have to sort of decide for yourself. Okay. My question is this: will we have two windows in 26, one for DV27, one for DV28, according to your opinion? When will the registration start? I think we're quite likely to see two registration periods in 2026. Yes, exactly as you said. We're likely to see there will be a DV27. I'm like 99.9% certain there's going to be a DV27 entry period, right? Normally they would then do DV28 in October, because they've made some changes that have allowed them to delay the DV27 period. They could say they're delaying the DV28 period and actually change that going forward. They don't need that sort of 6-month timeline in order to do this entry period anymore. They used to need it because the way they were doing the background checking and everything else of the entries used to be more manual than it is today. It hasn't been manual for at least 2 or 3 years. And so, for example, the photo rejection part, where they're rejecting cases, and this is the most commonly rejected number of cases, is based on the photos. So that now happens entirely by programs, software doing that, applying AI to the photos, 100% through AI, as I understand it. And that change was made about 3 years ago, 2 or 3 years ago. Prior to that, it was somewhat manual. They had people actually looking at some of the photos. They had software programs going through. There was, periods of time when they've changed. At one point, it was all manual, I should imagine. Then later, they were able to use software to do some of it, but the software was then putting some cases out for manual review, and those were being manually reviewed for some years. And so it was partially sort of software done. Now it's entirely software done. And with the changes they've made recently, like adding the passport rule and that sort of thing, they'll be able to enhance their background checking procedures and reduce fraud a lot. So, it's likely that they say, you know what, we can condense the time period. So maybe they don't have to run the DV28 entry period in October. That might be pushed into next year, right? That's a possibility, and that might become the more normal timeline, right? So it might change things going forward. But there is a possibility that we might see 2 entry periods this year. Yes, there is that possibility. I don't know. I wish I had better information for you, but that's just my assumption. Okay. What are the chances of having DV27 applications? About 99.9%. Right, that's the chances. Britt, are there going to be any court proceedings currently going on to challenge Trump 75 countries pause that you know of? If there is, can that be positive? There is. Oh, this is something else I meant to mention. On the 75 country pause in particular, that is a blatant APA problem for the government. They are changing administrative policy in a dramatic way, and they didn't go through the correct APA procedures in order to do that. And so there are lawsuits out there at the moment, a number of lawsuits for DV and also not for DV, that are trying to attack that policy. And one of the possible outcomes of at least a couple of cases, I think Clinic has this possible outcome, is if you can take that policy and take away the policy, which was January 14th, I think it was. If you can take away that policy and you can say that policy was illegal and therefore needs to be vacated, then it disappears for everybody. The 75 country pause disappears for everybody. Now, a DV lottery will still have the DV pause unless that could be taken down. But the 75 country pause might disappear for all sorts of visas through one of these lawsuits that's currently going on, non-DV, right? I think it's Clinic that is attacking that and trying to get that policy vacated. I think I could be wrong. So there is a possibility of the 75 country pause coming down. Now, the 75 country pause is also being attacked in the DV lottery cases, which is why I've been talking about Red Eagle Law and Impact, because those are the 2 law firms that I'm aware of that are doing those lawsuits. And I think there may be some other lawyers doing similar sort of lawsuits. That happened before in Gomez days. There were other law firms that got on the bus, basically. Okay. Let's see. Hi, Britt. My assistant's from Somalia, but I was born in Kenya. Will DV lottery allow me to apply as Kenya? Please, I need to answer. Yes, you're Kenyan as far as the DV lottery is concerned. The DV lottery is based, very important you understand this, very important, right, that you understand this. It's based on the place you were born. Not the place that you want to bullshit and pretend is the place you were born, but the place you were actually born, right? And so don't lie about this, but if you were actually born in Kenya, then you are Kenyan as far as the DV lottery is concerned for US immigration law, okay? Now, it's not important whether you've got a Kenyan passport or not or whatever. The point is, have you got documentation to show that you were born in Kenya? So yes, it is based on your place of birth. Last question. Oh, if you asked lots of questions. I scrolled up a bit, Joe, but I didn't go back right to the top. So I've sort of started going down my list of questions here. I may have missed some of your questions. Do you think it would be any benefit for people to write a letter to congressmen/reps and bringing their attention to the situation of INA law, DV27 being violated and impossibility to sue? For DV27, I wouldn't. DV27 is going to happen, Joe. It's going to happen. It's just, I wouldn't personally be spending a lot of time on that particular thing. In terms of the unfairness going on in immigration at the moment because of the government's actions, that is being discussed by various Congress people and representatives. People are waking up to that now. There's a guy called David Beer from the Cato Institute. He actually follows me on Twitter, which I'm quite proud of. He follows me on Twitter. So, but he's a smart guy. In fact, I'm going to reach out to him at some point and see if he'll actually give me a little bit of interview time, because it would be a fun thing to interview. But he's a smart guy, works at the Cato Institute, which is a libertarian. I want to point that out. It's a libertarian institute. They're neither Democrat nor Republican. They are, they take a central position. But he's been very instrumental in making sure that Congress do understand the harm that's being done by the current administration for immigration. I'm grateful to him for doing that. David Beer is his name, Bier. And from the Cato Institute, and he's written a couple of really good reports showing the benefits of immigrants and how they are how they add to the economy and so on. So he's doing really good work in fighting for for immigration in general, and he's testified numerous times in front of Congress. And you'll occasionally, at least on my feeds of TikTok and so on. He pops up in my feeds occasionally with some of the arguments that he's made in front of Congress, and I think he's actually scored some good goals. He's actually got them to realize that there is real harm being done, and it's not innocuous. And even from some of the from the other side, from the Republican side, some of those have actually listened to him as well. They've questioned him. And they seem to have listened at times. People I do not like at all have listened to him. I'm thinking of the other Kennedy, the religious nutcase Kennedy, not the healthcare Kennedy, the other one. Absolute pain in the ass, that guy, and brings his religion into Congress, which shouldn't be allowed. I mean, it just shouldn't be allowed at all. But he does that all the time, anyway, so he's questioned, and I've seen him sort of the lights turning on, and Kennedy's not the brightest spark at all, but I've seen the lights turning on in his head when he's been questioning David Beer on some of these matters. So it's quite good. So yeah, I wouldn't write Joe for DV27, and I think they already are aware for all the other immigration bullshit that's going on. Anyway. Could you all stop asking about DV27 application answers? I'm skeptical. When it's announced, we will know. You're correct, Dunlop. That's exactly right. Yeah. Hi, I'm from Gambia. My DV interview is May 19th. I saw about a possible visa suspension. Should I still attend my interview? Oh, I want to address this. Curtis made a statement this week about 221G. Once this Karamova thing was discussed in his live, he actually made a statement that I kind of disagree with, which was that you actually, he said, I'm paraphrasing, I don't know exactly what he said, I can't remember exactly what he said, but basically the import of what he said was that getting onto 221G, like attending your interview and being put onto 221G, puts you in a marginally worse position than not attending the interview at all. And that is sort of true. This perception that the government has that putting you onto 221G is like, we're done with you. That is a bit of a risk that the court might fall on that side, and therefore by attending the interview, you actually made your case a little bit worse, right? Nothing you can do about it if you've already attended your interview. Nothing you can do about that now, but that was his perspective then, right? And thank you, no. And so I needed that. Thank you. So now I slightly disagree with Curtis over this, I have to say, because if everybody delays their interview until the last minute, until the pauses are gone, there won't be enough time for all these interviews to happen, and capacity will be a massive problem. And so, if I stand back and look at the playing field for the whole group, people not attending 221G will result in less visas being issued. And so, and if you go for your interview right now on May 19th, Mohammed, you're going to be refused under 221G. You're not going to be magically given a visa, because everybody is being refused under 221G, right? And so, you have to look into your own heart and your own bank balance and so on, and decide whether you think you're going to be in a better position by attending the interview and being on 221G, having spent the money, and this is kind of critical here, depending on your financial situation, the money that you spend on the interview may be lost if you cannot get your visa by September 30th, right? So you have to understand the risks that you're taking by attending the interview and spending that money for the medical and for the interview fee and so on. None of that money is going to come back to you, right? None of that is refundable. There's no way that's coming back to you, right? So, so is the money a problem? That's one thing. But if the pause is lifted, let's say late in the year, then by attending your interview, you will be in a position where your visa could then be issued pretty quickly, right? And that might put you in a stronger position. And so maybe you feel that gamble is worthwhile. I understand why Curtis said what he said. I think he kind of overreacted a little bit, in my opinion. Again, happy to have that conversation with Curtis, if he feels I'm sort of misstating his position or anything. I think his Karamova reaction is a little bit of an overreaction. Karamova is powerful, and I'm not suggesting it's not. But I can't believe that we can't point out the differences in this particular thing and rip this 221G argument and the Karamova argument out of their hands. I can't believe a decent set of lawyers can't make that argument. It just doesn't make sense to me that you can hold by that position for DV lottery cases in particular. In fact, for any cases, but particularly for DV lottery. So, anyways, should you attend your interview? It's a personal decision. I personally would, and I've been saying, if you're affected by the two pauses, DV lottery pause and 75 country pause, I would personally attend the interview. But I do understand why, for some people, they may not want to risk that money, and that's probably the biggest reason not to go. Is probably the money that you're risking, and to an extent, this point that Curtis made this week about the 221G and Karamova and all of that, and that you're actually putting yourself into a slightly worse position. I get that. Now, for the 39 country travel ban, I don't recommend people go to interview because fundamentally, I don't think there's a chance that the travel ban will be removed before September 30th. And that's the problem there, right? I do think there's a very good chance that the 75 country pause and the DV lottery pause could be removed by September 30th, but I'm not confident about the travel ban in that same way, which is why I tell people, you probably don't want to go to the interview if you're affected by the 39 country travel ban, right? The other thing is you get a final refusal from those countries. You get a 214. I've forgotten. I was going to say 214B, but I think I'm confusing that. But you get a final refusal anyway it's 212F. That's what you get. You get a refusal under 212F. If you're from the travel ban country, you get this final refusal, and that is a final refusal, and it's difficult to overturn that later. There may be a way of overturning that later if the travel ban is removed, but only if it's removed by the 30th of September, which, as I say, I think is a very unlikely thing. And even if it's removed by then, they don't have to reopen a case and say, oh, well, you were under the travel ban earlier, but it's now, let's say it's mid-September, the travel ban is removed. Do they reopen those cases? They don't have to. And so, that's the problem with that. So, as I say, my perspective on whether you should attend the interview or not varies based on which ban or which pauses you're under, and how much money you have personally, and how much it would affect your life to spend the money and not get the visas, etc. You have to weigh all of that up. It's a personal decision. Let's see. Greetings, Simon. Is it possible for someone who lives in a country that got in the 75 country ban to participate in DV lottery and win? Yes, 100%. The 75 country pause and the DV lottery pause and the travel ban, to an extent, none of those affect who is selected in the entry process for DV lottery. So if your country is eligible, but under the ban or 75 country pause or so on, you're still able to enter the DV lottery, and you still will be selected in DV lottery, but you might later on be affected by, by the pauses or the bans or whatever. We don't know, right? Now, I absolutely think you should, if you're affected by the 75 country pause, particularly, or the DV pause, particularly, you should absolutely just ignore that and enter DV27, because that's very unlikely to still be there for DV27, right? For the travel ban, I still would recommend you enter, because it could come down, right? If you enter DV27, when that opens over the next month or two or whatever, it doesn't start until October of this year, and it goes on until September 30th of next year. So it's a long period of time where you can be interviewed, and the laws can change or the policies can change between now and then. So absolutely, you should enter, and you could be selected. Okay. I just read Curtis Morrison's recent tweet, and it seems that the relief will only be for plaintiffs in Ivanov versus Trump. I wish I had joined the lawsuit and hope Red Eagle will have another one. Yeah, so Red Eagle have an interest list for another lawsuit. I know they're going to be doing one for USCIS, which is adjustment of status cases. But I think they might be doing another one for DV lottery consular processing as well. So go into their webpage and have a look at the interest list and just sign up for that. There's no harm in signing up for the interest lists, right? So at least you get to hear about whatever they do next, right? Now, just understand again, Curtis and Impact, they are not working for anybody except their plaintiffs, right? So they are not going to argue this point they're not going to argue against the government's request that any relief be crafted only for the plaintiffs. We can't expect them to do that. You need to understand that. There's no point in whining and complaining about that. They're not working for you unless you've paid them to work for you. They're lawyers, right? That's what they do. And in fact, as I said earlier, I sort of hinted earlier, I think, if you are a plaintiff and only plaintiffs are given priority, then you're actually better off if non-plaintiffs are not given priority, right? If non-plaintiffs are not given relief, you're actually better off if that's, So if Curtis, Red Eagle Law and Impact, if they really want to do what's best for their clients, they won't argue this point that that the government have put forward, that the relief should only be for the plaintiffs. And you can't blame them for that, because that's the right thing for them to do for their clients. It's as simple as that. You could get pissed off about it, you can get angry about it, and some of you will, and some of you will probably blame me and all this sort of normal bullshit that goes on. But that's the reality of it, and we all have to act like adults and understand and expect certain things to happen. Now, I would also say I don't 100%. I don't think it's 100% certain that that's the only way this ends up. I think there is a chance that it ends up in a different way. But if I sort of considered all the possible outcomes and allocated each one of them sort of a possibility rating, if I did that, and I hate doing that, I don't publish those sort of those sort of percentage. I think it's 30% this way and 40% this way. But if I had done that before, I think my strength in my opinion that relief would come for other people other than plaintiffs probably decreased last night when I saw that note from, or that part of the motion from the government, right? Because that's basically it's almost a gift. It's almost a gift to the plaintiffs to say that, right? You're not going to get them to argue that, right? So anyway, I hope you were able to explain to the lawyers the points you explained to us at the beginning of the stream to the lawyers in a similarly simple manner. Look, they're much smarter than I am, Joe. They understand all of these points. They have access to all the information, etc., and they're legally trained. They know much better than I do. I'm just putting my my perspective on this, my take on this. But I appreciate your support in your in your comment there. That's sweet. Simon, it's essential that you prove an information training to our lawyers about DV details issues about these lawsuits, how to fight with government lawyers. I provide that in the background in terms of I've given them some information in the past, but they decide what is important, what isn't important. The report, for example, that I showed earlier at the beginning of the live, that shows how interviews are declining and the obvious connection between the government suppressing the visa bulletin, which, by the way, should be in the administrative record. There should be some email, and if they haven't revealed it, that's interesting. There should be some cable or email that goes to the visa office saying, "Hey, we want to keep the EU number at 20,000. Don't increase the numbers for the time being." There's probably that either happened by a phone call or it happened by an email. If it happened by a phone call, we don't have a record of it. But if it happened by email, which is more likely, there should be an email out there. Hint, hint, lawyers. There should be an email that says, to the visa office, don't increase the numbers, please. It wouldn't suit us to increase the numbers. So anyway, by the government suppressing the numbers and achieving the low number of interviews, and also limiting the number of people who've got a standing claim, they're doing damage. So we'll have to see. I don't know what will happen in the next visa bulletin. I wonder if they've got the balls, frankly, to do this again, right, for a fourth month running. I mean, it just, how obvious do they want to make it that they are screwing with the numbers? I don't know. My interview has done April 2nd, and I got 221G. Can we get a visa before September 30th? Any chance? There is chance. I think there's chance. I think there's chance for everybody. Obviously, like I said, there's probably a little bit more chance now if you're a plaintiff on one of these lawsuits. But it's up to you whether you want to participate in that or not. Yeah, I've done that one to death. Brit the King. Did you see the King was the real King was here in America the other day? That was kind of fun. He did a great speech to Congress, which was really impressive. And quite proud of our royal family. I am a royalist, actually. It will surprise some of you. I'm a royalist. Charles, well, I mean, I obviously, most of my life, I had Queen Elizabeth as my queen, who is an impressive queen by any measure of the word. You may not agree with everything the British royal family does, and many people don't. But fundamentally, they are the royal family of my original country, and so I pay them that respect. But anyway, I'm not sad. I'm not the king. I'm just a dude. Let's see. Should I participate in a lawsuit? Any benefits for me if I participate in the lawsuit? What sort of benefits are you expecting? Like a discount at Burger King? Free fries at McDonald's? What benefits are you expecting? The benefit is the only question here is whether you get your visa or not, right? And the lawsuit makes it more likely, I would say, or lawsuits make it more likely that you will get your visa. There is also a downside. I alluded to this morning. The day the lawsuits were filed, we lost the chance of ever knowing whether the DV lottery pools or the 75 country pools would have been taken down by the government anyway, right? The day they were filed, that water went under the bridge. We're now living in a world where the lawsuits were filed. The other thing that has happened is it's almost like the government's position has strengthened in their resolve to argue because of the lawsuits, right? Now, that I could be misreading that. Maybe I'm misreading that. But this latest response, even arguing, for example, the standing on the DV27 thing, it's like, I knew it would be, it would be a comprehensive and good response. But their arguments are, some of them are incredibly petty and stupid, etc., and they're arguing from a very weak position. But having said that, they're making good, strong arguments. They're arguing well. Now, is this emboldening the government to, if they can win these lawsuits? Maybe they feel like they're doing good in the arguing. I don't know. But it may be that the lawsuits, in effect, increase the length of time when the particularly the DV lottery pause would be in effect. It's possible. It's just one possibility. And like I said, I'm not looking to. I said this morning, I'm not complaining about that. I'm not trying to assign blame about that. It is what it is. And the lawsuits were absolutely necessary. Once it went to 90 days of delay, the lawsuits were absolutely necessary. I said that from the very beginning. If some of you were paying attention to what I was saying back in January and February and March and so on, I was saying at the time, 30 to 60 days is a reasonable delay, and you can't really sue for that, right? And what I said was, if it goes to 90 days plus, right, and you can rewind the tapes and you can hear me say exactly this, if it went to 90 days plus, that's clearly unreasonable and they should therefore be sued, right? That's what I've said from the beginning. Lo and behold, in the administrative record, it said a timeline of when it should be, of when this policy should be reviewed, 90 days. Well, blow me. It's almost like I had a clue of what I was talking about. It's almost like I'm not a completely stupid old man. So they had a 90-day date in there, and they blew their own 90-day date. So that's kind of interesting in a sense. But clearly, once they went over those 90 days and they didn't take any action to fix the chaos they were causing, they needed to be sued. And I took that position from the very beginning. I was hoping we wouldn't need to sue them, to be perfectly honest. I was hopeful that within 30 to 60 days they would have done a good faith job of trying to fix whatever problems they thought were existing. But once they went over 90 days, it's clearly not a good faith effort anymore. It's obvious that there's just animus. There's hatred for this program, and they are using things that happen, like the MIT professor and that sort of thing. They're using those things as excuses to achieve what they want to achieve. And it's an underhanded, disingenuous way to behave. They deserve to be sued for it, and they don't have these rights. If the lawsuits are well constructed, we should be able to take this down, because under the APA, they don't have this right. Under the way that the government in this country is supposed to run, they don't have the right to make the changes they've made. Okay, so anyway, we'll see. Okay, let me just see if I can go through. Hi, Grandpa. Is that really my grandson? One of my grandkids? I've got 4 grandkids. Have I got 4? No. What am I saying? I've got 8 grandkids. You see, that's how old I am. Well, actually, I might even have more than that. I don't know. I've got one son that's producing grandkids randomly all over the place. And, long story, but I can't quite keep track of what he's done so far. So I have some number of grandkids that's certainly more than 4, certainly more than 8, or at least 8, and maybe more. Could be more than that. He's a chip off the old block, I'm afraid. Anyway, if relief is granted only to the plaintiffs, we'll follow on lawsuits by others, go through the full process again, or can they be decided more quickly based on the earlier judgment? I don't know that. My assumption is, and it's only an assumption, is that a subsequent follow-on lawsuit will be able to achieve the same goals a bit faster than the original lawsuit, because they will try and tack on to the original judgment in some way. But I could be wrong about that. I think timing is going to be very, very particular. So if they can file a lawsuit before, the existing lawsuits are decided, here's the thing: you're going to have to decide. You're going to have the follow-on lawsuits can't wait for the complete win, wait for that lawsuit to be finished, and then file. In my opinion, that's not as effective, and I could have this wrong, but I think that the best time to file a follow-on lawsuit is before the other lawsuit is ended, because if you can do that, you can actually become part of that lawsuit. You can say, oh, here's another lawsuit. It's connected to this lawsuit. It's got all the same wording and everything else, and so we're telling you that it's connected, and the judge will accept that, and therefore a follow-on lawsuit becomes a part of the main lawsuit that's already about to be decided, and therefore gets a quick win, right? That happened in the Gomez days with some of the cases. I can't remember all the names, like Good Luck and so on. But so that happened back in those sort of 2020 and 2021 lawsuit days. Now, on the other hand, if summary judgment is given, and unless it's sort of some sort of monitoring period or something, I don't know how the lawyers can piggyback onto that lawsuit. I think they might be starting a new lawsuit again. So anyway, this question is really for the lawyers to figure out and for them to answer. But timing of that lawsuit might become quite critical, might be quite important when they file that, and when and they may not have a very large window of time to actually onboard people into that lawsuit. So do sign up for the interest lists, and I'll try and find out whether Impact are doing one as well. I know Red Eagle have got an interest list, but I'll try and find out about Impact and let you know. Okay. Hi Britt, sorry, my name is Briss. I'm from Benin, a country near Nigeria in Africa. Yes, I know it. I have a map and everything. I would like to know if the date for the entries for DV27 have already been chosen. No, they haven't, Briss. The dates are not published yet. We don't know when it's going to be released. Okay, but I'm expecting it to be soon. Do you think the June visa bulletin was sent automatically? Got excited? No. No. It's not been published. It won't be published for a few days yet. Okay. Hey up, Simon. Hey, Daniel. How are you? Eki Thump. Like 99% of the viewers don't know what the hell I just said. But anyway, hey up. Good seeing you again. You're the pickle guy, right? Still hoping for DV to open soon before my passport runs out in June. All the best from the north of England. All best to you, mate. Indeed. You are a great arguer, says Confusion. I love a good argument. I'm not quite in lawyer league. They are professional arguers. I'm just an amateur at this, but I do enjoy it. Today marks exactly 1 year for the release of DV26. Where's DV27? Good point. I don't know. Simon, there's dispiriting chatter in the news about the America First Immigration Act 2026 bill by Rep. Moore. Would it would end DV lottery? Do you think it will pass or get anywhere near passing in the House? No, we're in weird times, no doubt, politically speaking. But I can tell you, I've been talking, as a talking head about DV lottery since 2013. I think 2013, so 13 years. And in all of those 13 years, literally every single one of those 13 years, there has always been a bill in the House, going through the House, going through, from somewhere, which attempts to end DV lottery. It's always there. The same bills come back time and time again. They always try, right? Right now, they're trying to codify a lot of codify, meaning they're trying to create laws to do what Trump is already doing, right? And so, things like removing the DV lottery is something that Trump is trying to do through this administrative procedure stuff, right? And so, in a sense, they would love to codify that, but in general, there's enough difference of opinion in both houses in Congress to make sure that immigration reform can't go through at the moment. And once we get to November and the midterm elections, the Republicans' power will be fully removed. I fully believe there's going to be a big swing towards the Democrats, and because the Congress will then be controlled, at least partially, at least the House will be controlled by Democrats. Even if the Senate isn't, the Senate might stay Republican, and the presidency is Republican, of course. But that creates a bit of a stalemate situation, so that it's very, very difficult to get any legislation through at that point. So it's unlikely they get any sort of bill through now. There's really not even enough time to get a bill through now. It's not important enough for them to rush a bill through to take DV lottery away. And what by the time they actually get another bill crafted or try and add that bill into something else, it's going to be November. Everyone's going to be thinking about midterm elections, and then the Democrats will take more power in the House. So that will stop the Republicans doing what they would like to do. Okay, so I'm not really worried about it personally. Hi, sir. Liberia DV winner case AF 36K. Haven't received 2NL yet. Do you think I'll receive it, or I should forget about it and play again? DV shout out. DV 27. Okay, so you and I don't have a lot of decision making in this, right? It's not a question of whether you should forget about it, right? In reality, you won't forget about it. I mean, if I said to you, yeah, you should forget about it. If I said that, and I'm not saying that, but if I said that, you wouldn't actually forget about it anyway. You would still open your email when that email comes through saying check the ESC page. You'll still listen to what's going on, because hope dies last. People have told me that phrase over the last few years. I've heard it many, many times. Hope dies last. So you will obviously continue to hope. Will it work out for you? I don't know. It depends on your embassy more than anything else. You're already current, and so it depends on your embassy whether they get to your case number or not and schedule cases around your case number. And I don't know how that's going to work out for you, and I don't know what's going to happen in the DV cases in terms of lawsuits and the pause and everything else. There's just too much unknown. Now, obviously, there's lots of risk, and so you certainly don't want to, sort of be making plans to move to America on October the 1st or something, because there's a lot of risk against you. But there's nothing you can do to sort of make a decision that says you're going to switch off your brain and not think about DV lottery till next year or something. Unfortunately, you're not going to be able to do that. So you just have to, wait and see. I say this, and I've been saying it for years, wait and see. And people hate me saying it. But there's a lot of wisdom in that phrase, to wait and see. There is a lot of wisdom in that phrase. And, I wish people really should listen a little bit more when I say that, or just listen to their own internal voice that says, yeah, I just have to wait. There are some things we can't control in life. And, whether you believe in God or whether you don't believe in God or whatever, some things are just going to happen. They're outside of your control. Something else is going to make them happen. Maybe your faith tells you that you'll be looked after. I don't know. I don't have that faith, but I do believe, that things are outside of our control sometimes, and you just have to wait and see. Okay, so that's all you can do. Okay. With the June bulletin at 20,000 for Europe, do you think the high cutoffs mean they're planning a massive issuance burst once the security review is finished? No, Carla. That's extremely. Sometimes our brains work against us. We think of the most advantageous thing for ourselves. We think about what we want to happen, and we project that onto the government, and we assume that they want that to happen too. They don't want that to happen. They're not looking to do a massive burst of issuances. They don't give a damn about us. They don't. And I know you want them to have that sort of care for us, but they don't. This particular administration don't give a damn about us. They are horrible people. And they're putting lots of horrible people into important positions. Some really despicable people are being put into powerful positions. And they are taking actions that are really, thoughtless and outrageous. And in any normal administration wouldn't have been allowed, but this is not a normal administration. So when you think things that are going to get better, I understand it comes from a place of optimism, and I don't want to take that away from you. But it's not really justified by any evidence I've seen. Should we put it that way? So I hope we see the chaos factor where they do a high cutoff in the last few visa bulletins. They may do, but just think about this. Like, the government just answered a motion yesterday by saying, well, the visa bulletin's not even high. Those people are not current, therefore they have no standing. Wouldn't it be kind of surprising if the visa bulletin was suddenly released with a super high cutoff, like nullifying that point that was just made in the court cases. I mean, it feels like it feels unlikely that that's going to happen, but who knows? I don't know. I don't have any inside information about that. All right. I would like to know if all the countries have access to the DV lottery, like there is a lot of countries that have been denied to enter in USA. I'm not quite sure which angle your question is from. There are certain countries that are not eligible to participate in the DV lottery because their immigration over a 5-year rolling period is above 50,000 people in 3 certain categories. There's a whole law that controls the operation of the DV lottery and which countries can participate in it. And so, I created a video about that a few weeks ago. And so if you're interested in sort of my understanding of that, you can go and have a look at that video. Then you may be referring to the 75 country pause. There is a lot of countries that have been denied to enter. That's true too. There's also the travel ban. Maybe your question is about the travel ban. That's also denied. And probably thinking about it, maybe it's mostly about that. But I don't really know what your question is. I guess it's a long-winded way of saying I don't know what your question is. Did I understand correctly that if the standing argument is accepted, only some of the plaintiffs will get relief, those who are current? Thanks for your help. Yeah, so the court case will not tell the government to move the visa bulletin. Now, I think in the court case, our lawyers, should be making the point that the government is clearly suppressing the visa bulletin numbers and thereby causing the lack of standing, and that should be applied. But the Judge Leon is not going to turn around and say, "Hey, I'm going to move the visa bulletin." That's not going to happen. And if you're not current, you can't get interviewed, right? And so one thing is standing in the case. That's one important point, yes. But I mean, the reality is, even if the plaintiffs win, if you're not current, you're not going to get an interview. I mean, that's as simple as that. So the visa bulletin is also important, right? So, yeah. I have a visa appointment in June, and my derivative is in the US on F1 visa in the US. So when I go in June, can I request another date for her with September 30th? Oh man, you would be better off bringing your relative back to your interview, but right now it's probably not, the smart thing to do. How would you handle that? Maybe talk to a lawyer about that one. That's kind of tricky because there's so much going on. Like, you've got your visa appointment in June, but are you going to be given a visa? Like, and you don't want your relative, is it your daughter, your derivative? You don't want your derivative to leave America, maybe have her F1 visa cancelled, because of applying for that. I mean, I don't know. Very tricky situation. Speak to a lawyer and make sure you've got some good advice about that. It's a little bit more that I don't know your situation well enough, and I don't know what's going to happen with all these pauses and so on. So it's very difficult to make that choice. If worst came to the worst, you could emigrate into the USA and then sponsor your derivative through an I-130 case. You could do that, right? Later. So maybe leave the F1 visa alone in the States. May not be ideal, but it might be possible to do that. Okay. Let's see. Hi, Simon. Selected in one DV26 based on birth country, but got 221G refusal based on nationality, 75 country pause, and DV pause. Isn't this conflicting? No, I mean, you could be on both pauses. You're only going to get a 221G update. But you might be subject to both pauses, both the DV lottery pause and the 75 country pause, right? And so then you need both of those pauses to be removed in order for your 221G status to change to issue, right? So there's a conflict between those two things. If you happen to be, subject to either one of those courses. Okay. Let's see. Is new vetting protocol is applicable for DV applicant too? Yes, I think there is. There was a USCIS announcement, which is adjustment of status cases. In general, the vetting, the background checking is probably being enhanced behind the scenes, both for USCIS cases, adjustment of status, and probably also for Department of State. So I think in general, it should be no surprise to us. There's been various announcements that background checking is increasing. They're obviously going to be doing more of that. And now as they move forward with DV lottery and they have passport information and that sort of thing, they're going to be doing more and more of that background checking. I mean, this government is serious about keeping the wrong people out. Unfortunately, it's also serious about keeping the right people out. That's the problem I have. I don't mind them keeping terrorists out. I don't mind them keeping unauthorized people out. That's fair enough. That's what I expect them to do. They're supposed to do that. What I mind is them stopping legal immigration and people who are doing the process legally, who are decent people, who are good people, who are not terrorists, who are not looking to cause harm, etc. That's what I mind. And I don't like this perspective that Rubio seems to have, that he can read everybody's mind. He knows what they're thinking and what they think today. I've become, for example, more hard against my position against the government of Israel. And note, I'm not talking about Jews. I'm talking about the government of Israel. But the government of Israel, have been, frankly, well, they've misbehaved for 70 years. I mean, they've been behaving badly for 70 years, right? And if you're pro-Israel in this whole argument, then I'm sorry, I happen to disagree with you. But I'm not a fan at all. That's putting it lightly, of what's been done in Palestine. I'm not a fan of how the Israeli government behave. I'm not a fan of those people. I think they're a disgrace, frankly. That doesn't mean that I'm not supportive of Jews. That just means I'm pissed off with the Israeli government. I'm pissed off that we as America, are being led by the Israeli government, which is what's happening today, right? Now, all of those things I just said are opinions that have become stronger in me, or I've formed in the past few years. And I became a US citizen a few years ago, in 2021, I think it was. When did I become a US citizen? 21, I think. Or 22. I have my passport here. My daughter's passport, same thing. 22. So in 2022, I became a US citizen. And Rubio thinks that he can go back in my record and say, well, you were pro-Palestine, anti-Israel years ago, right? So when you got your green card, or when you went for naturalization. No, I wasn't. I've become that way. And if I speak out about it today, it's not that I hold the same opinions that I had then, and I wasn't asked any questions and didn't lie about it then. And so you can't go back and try and throw me out the country and denaturalize me and all those sort of things, because of the opinions I hold today, because the circumstances that you have created have made me feel that way, but they would try. I mean, I'm probably on a list somewhere of people that are anti-Israel and or pro-Palestine or whatever, and subject to removal if they could remove me. I'm probably on some bloody list somewhere. Right? Well, come on, Rubio, come at me. I got lawyers. I know some lawyers. I'm happy to defend myself. Anyway, so yeah, we'll see. I'm a uni student expected to graduate next year. Say I apply and win DV27 with a low case number. My interview is October, November this year. Would the consular reject my visa because I'm in school? No, because normally, Nelly, in order to get into university, you will have had to have qualified through a formal course of education that is equivalent to a high school graduate in the USA. So when a kid over in America gets to about 18 years old, 17 or 18, my daughter's about to graduate, she's 17, so they can graduate while they're 17. But a 17 or 18-year-old goes through high school in America, and at the end of high school, they're then qualified enough, if they've graduated from high school, to enter college or university. So if you're in university doing a bachelor's degree, then and you achieved that goal through a formal course of education, then you achieved the standard required for the DV lottery at the end of your high school education, just before you entered university. So the fact that you're in university doesn't make any difference. The fact that you haven't achieved your bachelor's degree or any degree or whatever, that doesn't make any difference. You actually qualified for the DV lottery prior to entering the university. It's because you were qualified to enter university. Now, slight caveat to that, there are some countries where, and some instances where people go through, they don't achieve a high school education sufficient enough to go into university, but they instead take some sort of makeup course or sort of adult education course or whatever, and that gets them into university. That would not qualify you to be in DV lottery, right? Now, you need to weigh that up, and you need to know about your education. I don't know your country or your education level, but you probably met the requirement prior to entering university. It's not university that causes that. Okay, Nelly, hope that's clear. Hi, Brett. Did you consider to get green card with EB1 back when you were on H1B? No. The latest time I came on H1B was in 2014, and at that time I already knew that we were green card winners. So no, I didn't need to, because I knew we were going to be able to adjust status to green card. And anyway, long story, but no, I didn't do that. Thanks for asking that. Hi, Simon. I want to go to the US as a tourist, but I don't know if the bonds are charged on everyone or just people who are not employed, or doesn't show proof that they are going to come back. You must go if you're going to a non-immigrant visa interview, and I only talk about DV lottery, so I'll briefly cover this. But if you're going to a non-immigrant visa interview, the burden is on you to prove that you have ties to your home country and that you will return after your visa is over, or after your trip is over, or whatever, that you'll return home and that you'll play by the rules. And to strengthen that position, they've introduced some bonds in some countries. How the bonds are working exactly, how it will work for non-immigrant visas, I don't know. I don't know the level they're setting. I don't know how likely it is you'll be assessed a bond and so on. But I can tell you that I think it would be very unwise to go to an interview without good proof that you can show, hey, I have a house. I'm planning to go to America for 2 months, but I have a house. I own a house. I'm paying the bills. I'm not leaving the house. I'm not selling the house. I've got a job to come back to. I've got family here. My mum needs me to come back. You need to show those ties to your community, any ties that you have, to show that you're going to return. And if you don't do that, you're likely to be refused the non-immigrant visa. A lot of non-immigrant visas are refused for exactly that position. That's the 214B refusal that came into my head earlier. That's the most common type of refusal for non-immigrant visas. So do take account of it. As to the bonds, I don't know how that's being implemented and what the level of bonds are. Okay. If they're obviously screwing with the numbers, wouldn't that mean the pause will eventually be lifted and the visas be handed out in the future? Otherwise, why bother? No, they're not going to hand them out in the future. They can't hand the visas out after 30th of September. So, no. So I'm sort of understanding your point, the rocker, but not exactly. But so, yeah. But no, I don't think they're not doing things today to try and hand out more visas later. That's not what they're trying to do. They're trying to stifle or choke DV lottery through this. They don't care about DV lottery. They actually don't like it, right? So that's what they want to do. When it reaches September 30th, can they take all 55,000 people because time is going by really fast? We're not going to hit all the visas. So firstly, there are not 55,000 visas available this year. There's only 52,000 available. Some were taken by a different program, and that was announced at the beginning of the year. They have not done enough. They've only scheduled 14,350 interviews, which is about 28,000 people. That's all that's scheduled up until the end of June. In order to issue the 52,000 visas, they would have to schedule about 70,000 people, maybe 75,000 people, because a lot of people are on travel bans, etc. So they would even if they go for interview, they're not going to get their visa, right? So if they're at 28,000, and I think it's about that, they call it 30,000. They're at 30,000 people have been scheduled for interview up until the end of June. Then there's July, August, and September. They cannot possibly interview 45,000 people, even if they wanted to, and they clearly don't want it. But even if they wanted to, they couldn't interview 45,000 people in those last 3 months, right? And there's no evidence that they want to do any of that. There's no evidence. There's no reason to think that they want to do any of that, right? So it's not going to happen. We're creating this sort of illusion in our own minds because we want to believe they're nice people or whatever, but they're not nice people. And they don't want to give these visas out, and they don't want to follow the law, right? So they're not going to do that. So mathematically, in my opinion, I'm happy to state there is no freaking possible way that they're going to get anywhere close to 52,000 visas issued, because they simply don't have, the time left to be able to do that. They don't have it. It's gone. They killed that possibility. Okay, so no, that's not going to happen. And frankly, I think we're going to see more bad behavior. I don't believe they're suddenly going to change and be, scheduling thousands and thousands of appointments. Not unless they're told to do so by, a court. So, no, it's not going to happen. Do you think they will reach 55? No, they won't. That's what I'm saying. Did you support Brexit? No, of course not. I'm not an idiot. What do you think about UK rejoining EU in the future? I don't know. I haven't really thought about that. But that whole Brexit thing was from a perspective that if you understand who I am as a person and the sort of, the sort of opportunities and the sort of movement that I've emigrated a couple of times, actually. I've emigrated from the UK. I live in America. I know what it's like to work in a global economy. I work constantly with people from all over the world. I have meetings early morning, late at night, because I'm talking to people in, Costa Rica or India or Czechoslovakia, all over the place, right? So to me, to fight globalization is moronic, and the people that voted for Brexit are moronic because they didn't understand that was going to bring a lot of negative sort of aspects with it. And I'm sorry if you believed in Brexit. I don't know you, but there is only one answer. It's like support Brexit, moron. It's like MAGA, moron. It's the only sensible assessment you can make of these things, right? It's not TDS. It's not it's not those things. It's just the only sensible way you can look at things. If you've got half a brain, if you've got any ability to do any level of critical thinking, you know that some of these things are bloody obvious. MAGA was stupid. This administration's stupid. Brexit was stupid. Now, should we unwind the Brexit thing? I don't know. I don't know. I don't have a. Well, I sort of do have a dog in that hunt. One of our future options is to live back in Europe. We would never live in the UK again, I don't think. It doesn't make sense for us to try and live in the UK again. It's too cold and horrible weather. I mean, that's literally the only reason. I own a house in the UK. I own a very nice house in the UK, actually. and I've got family in the UK, but I couldn't force my wife to live there. It's like, she's been through enough. I don't want to force her to live in England. So maybe we live in Europe, but that would be in Spain probably, or maybe some of the other places of Southern Europe. Maybe it's a possibility, but not the UK. God, no. She was miserable with the weather there. It was a good place for us to live economically and from a business point of view, etc. When I was there, but no, it's not a good place for us, and it's purely for the weather. It's for not any other reason. Economically, I'm fine. I do very well in the UK, and I've got a house there, as I say. So I just wouldn't go back there now. Just doesn't make sense. What's the latest on 39 countries lawsuit? I saw somewhere that there was illegal. I think I've given that in this video. I covered that a lot. When will they start taking DV27 applications? When will they announce the results? I don't know, and I don't know. I don't know when they'll start the process, and I don't know when the results will be out. But I do believe it will happen soon. Okay, so that's it. There you go. All right, I'm just going to scan down, see if there's any last questions I should answer here. We're at about 2 hours, so this is an important one. I have an interview this Tuesday in Italy. I recently got a master's degree in tourism, and I have about 8,000 in savings. Tourism, by the way, a master's degree in tourism is the sort of degree I would be horrified if someone paid to get that in America. Horrified. It's it's just, the cost of education in America right now is through the roof, ridiculous price. And I'm sure you didn't do that in America, thank God. And so it probably didn't cost you a fortune. But honestly, it's just not worth the money to get an education like that in America at the moment. But anyway, hopefully you got it somewhere else, in Italy, for example. A great degree to have. I'm not knocking the degree. It's just, it's like having a master's degree in basket weaving. It's just not a valuable degree, and it certainly wouldn't justify the cost of that degree in America, which you'd be well into six figures to get a degree like that. And people have got to start making better decisions about how much the money they spend on university courses for degrees, and the whole environment is changing through AI. So, but anyway, I'm sure you'll be fine. I mean, I'm sure you'll be fine. You have about 8,000 in savings from your bank, but I don't have a Form I-134. Do you have any advice? Get more savings would be one piece of advice. You see, your degree in tourism, your master's degree in tourism, you're very highly qualified, but not that employable in America. I mean, it's not like you're going to walk into America and they say, oh, Hassan has got a master's degree in tourism. We've been waiting for Hassan. Like, we didn't have anybody else in America that understands tourism, right? I'm being a bit facetious. I'm sorry, Hassan. I hope you understand a British sense of humor. But, it's not like you're going to walk into a job immediately based on that master's degree. So that in your interview isn't going to be a massive, plus point in the pro column about you avoiding public charge, right? That's what I'm trying to explain to you. So your $8,000 will come into play. Like, it's a good amount of money, but it's not, generally speaking, enough. They generally want to see about 10, maybe a little bit more, $10,000 or a little bit more, in order to consider you to be perfectly safe. And if you don't have very good job prospects and you don't have very good savings, then an I-134 is the next thing that they would consider. But you don't have that, right? So, I'm just sort of weighing up all the things. So there's a little bit of a risk for you. By the way, before you go to your interview, go on to healthcare.gov and get yourself a health insurance quote and print that out if you can. So you can say that you understand the cost of health insurance, because that's one of the things that they're using to deny cases on public charge grounds. One of the things that they're using is that. Now, having said all of that, you're going to be put onto 221G anyway because of the pauses. So there is time for you to provide more documentation. after the interview if necessary. So anyway, good luck. And I hope you're not offended by what I said about your degree. I mean, it's good. I've got a master's degree in tourism, so well done you. But anyway, I'm trying to understand the current situation. Is it correct that the 39-country travel ban affects multiple visa types? Yes. While the information about 75-country pause applies to only immigrant visas. Yes, that's sort of correct. There's a lot you can read. Probably spend a little bit of time with Google to figure all of that out. Okay, bro, I have a spectacular question. I've got to read this one. Okay, so let's say if they start taking DV27 applications in June and DV28 in September, can we use the same photo in both processes since the time frame is less than 6 months? A spectacular question. I've never dealt with that question before. Well, okay, maybe last weekend and the weekend before that and the weekend before that. But yes, it is a spectacular question, Volkan. Now, let me sort of say this. Theoretically, you would be able to use the same photo, right? But I think, and I've had to sort of consider this and read up a little bit of information about this, because the government have now announced that they're going to do a little bit more, and I don't know what that means, but a little bit more on the reuse of photos. They specifically listed that in a recent announcement about some of the procedural changes they're going to be making. They don't like people reusing photos for multiple applications, right? Now, in 2017, there was a rule change or a policy change made in DV Lottery, and they announced that if you reused the photo from a previous year's DV entry, that could cause disqualification. In the end, they haven't, as far as I'm aware, disqualified any cases on the basis of that particular rule, the 2017 rule. However, there is a rule that says the photo shouldn't be more than 6 months old. So, technically speaking, if you can take a photo and within the same 6 month period, that photo, technically speaking, you should be able to use it for both entries. I personally, though, wouldn't do that, just in case they have some little software thing that says, check this photo against all the previous entries and disqualify the case if it's a reused photo. I would not take the risk for the sake of a few bucks. I would not take the risk, and that's what I said last weekend and the weekend before that. I think spend the extra $5, whatever it is, or take another photo, get 2 photos, take them separately for each entry period. And yes, I should put this. Yes, I have a website where you can get your DV Lottery photo. So obviously, yes, I've got skin in the game. You can go to dvphototool.com and you can take your photo and put it through there, and we'll produce a photo for you for an incredibly inexpensive price. We'll do that whole thing for you at dvphototool.com, and that gives you the best chance of being accepted. But like I say, I would personally recommend that you don't reuse the photo, even though it should work, right? Volkan says, "Bro, sarcasm is hilarious. I'm sorry, I'm terrible at it. It's a British thing." And probably many of you, it just goes straight over the top. But anyway, fun fact. Yeah. So let's just see. Okay. Oh, I think I'm close to the end of the question, so that's good. Let me just check that I haven't missed anything important. What are the chances of getting a green card with active investigation on past mistake by SEVP and USDA? Jesus, what are you talking about? SEVP and USDA. USDA is the US Drug Administration. What's SEVP? Do that affect green card approval? Mistake was reported by X to trouble. Jesus, I don't know what you're talking about. I think you probably need to give me a bit more information. There is, generally speaking, general advice I would say is, and I don't know what you're talking about exactly, I have no idea, but when you say past mistake, it infers a crime, right? And what will stop you from getting an immigration benefit is a crime involving moral turpitude. So you can Google the word CIMT, or the word the phrase CIMT, crime involving moral turpitude. The only thing I would say is the exact definition of crimes that are meeting that standard is a bit woolly. It's not immediately obvious. So some crimes would sound like, they're not a problem. Like, for example, drunk driving is not a crime of moral turpitude, generally speaking, for one offense. But if you do it multiple times, or if you hurt someone while you're drunk driving, if you run someone over and kill them or something, that can raise that crime to the level of crime involving moral turpitude, right? And therefore make you ineligible for immigration benefits. So you need to know that, if you can either you can ask me at BritSimonSays.com. Let's just, let me show you, BritSimonSays.com. There you go. You can ask me there at BritSimonSays.com and give me a little bit more detail. But if you don't want to share that detail in public, I don't do private consultations or answer questions privately. I don't do any of that. And so you should then speak to a lawyer and have a conversation with the lawyer to see whether whatever your past mistakes are that you're referring to will cause a problem or not. Okay, but I would need a bit more information. I'd need to know what SEVP is and what USDA is, but it sounds like drugs, and drugs can be a problem. I don't know. All right. Thank you for the response, Simon. It really gave me hope. Sorry, I left the live and watched the answer now. Good. Okay. When is the processing going to unpause for DV26? I don't know. When is the processing? Okay. How is the photo US TV photo tool? How is the photo? Us. Oh, it doesn't photo you. You take a photo on your phone, right? So you take a selfie, preferably using both of your hands on your phone, right? There's a reason for that. If you put your arm out, taking a selfie of yourself with your own phone, you tend to raise one shoulder more than the other. And our software can correct for that a little bit, but I don't want you to do that too much. So ideally, have somebody else take the photo of you with your phone or something, or you stand there with the phone with both hands and take a photo of yourself. Doesn't matter about the background, because we're going to take the background out in dvphototool.com. And don't, just look directly at the camera. Don't smile. I had some moron create a little video saying that our DV photo tool allowed bad photos to get through, because it showed an example of someone who's looking over there and took a photo like this, or had a photo taken from the side and only showed one side of the face. Our photo tool app doesn't check for that, because we assume that you're not a moron. And if you are a moron that can't take a photo looking directly at the camera, I can't help you. You're a moron, and you probably shouldn't be coming to America. So, because you're a moron, that's just the way it is. So, so if you're stupid enough, like that person who did that video, that can't understand why we didn't stop people from taking a photo, of the side of their ear, only one ear, then I'm sorry, I can't help you. I do need you to do a little bit of work, a little bit of thinking in order to help you make a photo. So if you look at the photo, look at the camera, you take a photo, and you don't smile, we'll be fine. If you are smiling, our software is going to say you're smiling. You shouldn't be doing that. If your eyes are closed, our software will pick that up. But there's certain tests that, although we could find them using the AI and we could put a warning message, we actually de-restricted it because, for example, we don't want to stop someone from taking a photo if they've had one ear cut off by mistake, right? Or if their hair covers their ear, etc. So there's certain AI tests that we've sort of toned down, we've dialed down the effectiveness with the assumption that you're not idiots. And if you are an idiot, then yeah, we're going to struggle. But you're going to struggle anyway. So you can go and check out dvphototool.com. You're going to get sick of me talking about that website. When the DV lottery is announced, I'll be talking about that website a lot. It'll be on every live session. Can the same law firm and group of lawyers file exactly the same lawsuit multiple times with different plaintiffs in the same court? No. The same law firm and group of lawyers, exactly the same lawsuit multiple times. No, you shouldn't be filing multiple lawsuits with this for the same people for the same problem in multiple lawsuits. No, you shouldn't be doing that. So no, they shouldn't be doing that. How much is the photo tool? It's like $6 for one photo. But if you're taking a family, like, you've got husband and wife and 2 kids sort of thing, you'll pay $5 for each one. So that's 4 people, that's $20. And for that $5, per photo for that photo thing, you're getting, the tool will check your photo. It'll remove the background, put in a white background. It'll check your photo. It'll adjust certain things for you without editing the image too much. It just changes the if you're angled, it can fix that a little bit, and it's gonna create the right size photo in the right format with the right file information, which is also important. It's going to do all of that all in one go. It's very quick and easy. You can do this yourself. You don't have to use my tool. You can do it yourself. But the thing is that people are making big mistakes, apparently. I mean, I don't know why. My photo tool is an attempt by me to try and cure the problem that I've seen, where I forget the numbers now, but it's almost 50%. If you look at the number of case numbers there are in the DV lottery, you notice that there are a massive number of holes, right? And the holes are the cases that have been rejected before the results are announced. And we know about 10% of the cases are rejected for fraud reasons, right? But that doesn't explain why something like 48% of the cases overall are rejected, why 48% of the cases are holes, right? So the difference between the 10% that we know are fraud and the 48% or so, or 45%, whatever it is, that are rejected, can't all be explained by anything else except bad photos. Okay, so there are country limitations, and those are some of the things. But again, I've applied this rule. I've looked at this. There is definitely a lot of people who are getting disqualified because they can't take a freaking photo. So that's what my website is trying to fix. Because I'm fed up of seeing people enter with bad photos, and they're ruining their own chances. Okay. So there you go. Right. Last question here. I had an interview 2 months ago, and the CX data is still ready. Didn't change to refused. Is it a problem? Should I email the embassy? It's a good question. It doesn't really matter. You can email the embassy if you want. It doesn't represent any particular problem with your case. It just means that they have been lazy in updating it. I suspect that's probably a small embassy, an embassy that doesn't see a lot of DV lottery cases, and sometimes they don't know how to work the system, or they forget to do the update. And it's simply that they've just forgotten to do the update into the SEAC database. So you could email them if you want to, but it doesn't really matter if you don't. You can contact them a little bit later once the pauses are removed. Okay, we'll call that a day. Thanks everyone for joining me. I've gone well over the 2 hours here, and I hope that was informative earlier. I talked about the lawsuits. The first 50 minutes of this session today were spent on the lawsuits and my take on the lawsuits, etc. So if you're interested in that, by all means, rewind, rewatch the video, and watch the first 50 minutes of this live session. I hope that was interesting and helpful to some of you. All right, everybody. Thanks a lot. Bye-bye now. Keep well.